Justice Aftab Alam, our beloved Professor Khanna, Professor Kaul, Professor Raina, my extremely esteemed and beloved colleagues who are all here in the front row, fellow students. Today is indeed a very important day. Apart from felicitating one of our most erudite and nicest professors, it also happens to be the 150th birth anniversary of Swami Vivekananda. This lecture is about other great sons of India like Swami Vivekananda, who formed our Constituent Assembly, and in the reasonably rapid 3 years that they were given to frame a constitution for us, actually gave us this constitution. But before going more into the Constituent Assembly and what exactly these people were faced with, I don't know how many of you have heard of the great Arthur Rubinstein. He was a great pianist. And he was once told after a concert, and he was an expert in Chopin, who was a great Polish composer, how brilliantly he had played. He very sarcastically looked at the person and said, I could have played an entire Chopin scherzo, which is a piece of about 10 minutes, with the notes that I left out. The notes I am going to leave out today would be more than a Chopin scherzo, I assure you. Because the subject was chosen by me, and the idea was that I myself wanted to learn how exactly our constitution came about. I plowed through the debates, I plowed through various other constitutions of the world, and ultimately was able to see this formidable task which was in front of our Constituent Assembly. Now, our Constituent Assembly, as most of you know, was formed in December 1946. It got its legal authority from a British Act of Parliament, Section 8 of the Indian Independence Act. And even though it was an elected body, it was elected in a peculiar way. There were some 217 members who were all elected by the provincial legislatures that had in turn been elected under the 6th schedule of the Government of India Act. Now, the 6th schedule of the Government of India Act did not believe, like our constitution, in adult franchise. You required to be both a taxpayer, a matriculate, and in many cases a property owner in order to exercise your right to vote. So ultimately, this Constituent Assembly was voted in by roughly 28.5% of the people of India. I think this is something which never left them, and which is something which stopped them throughout their proceedings. Two very great figures emerge, apart from the many others. One is Sir B.N. Rao, who actually was the constitutional advisor. He was not part of the Constituent Assembly, who later became one of our first judges in the International Court, and of course the great Dr. Ambedkar, who was chairman of the drafting committee. The very first draft was made by Sir B.N. Rao, then debated over by the entire Assembly, and ultimately drafts was circulated by Dr. Ambedkar, which then became our constitution. Now look at the mammoth task that faced these people. You had the Constitution of the United States, which is a constitution which is 200 odd years old. It consists only of 7 articles. Our constitution consists of 395. The first article very simply states that there shall be a Congress which consists of 2 legislatures, the upper and the lower, and goes on to enumerate the powers of Congress. The second, with equally simple language, goes on to speak of the executive branch of government, the president and their the persons who are chosen by him, because you remember that in the United States, the president is elected directly by the people. And unlike ours, who really is the head in the sense that he is the constitutional head, there he is the head of the executive arm of government. Under Article 3, they established a Supreme Court, and Congress was given the right to establish other courts. Under Article 4, states' rights generally were dealt with. Article 5 is very interesting and gives to the US Constitution its amending power. Now that amendment power was either to be exercised by both houses, 2/3 voting, and after then it was sent to the states for ratification, and 3/4 of the states had to ratify it. Don't forget, all these states were actual nations with constitutions of their own. It is only when this cumbersome process ultimately culminates that the US Constitution stands amended. As a result, there have been very few amendments, 27 in all, in 200 odd years. And then, of course, you have the famous Article 6, which makes it clear that the Constitution of the US and the laws of the US will in fact supersede all constitutions of states and state laws. 7 is inconsequential. And we had to wait till 1791 for the Bill of Rights to be incorporated by 10 amendments. Now this, in stark contrast to our constitution, was the US Constitution, the first in that sense of a great democratic government. The next, chronologically, is the British North America Act, which is again an act of the English Parliament of 1861. Now this laid down for the Dominion of Canada the legislative lists with which we are familiar in our Schedule 7. The only thing that it didn't have was a concurrent list. You had a Dominion list consisting of central subjects, and you had a provincial list which consisted of matters which basically were of a local nature. Next come to the Commonwealth of Australia Act, which is the 1900 British Act of Parliament. Here again, there are various features borrowed later, most important being the trade, commerce and intercourse part. But what was most interesting here again is the amendment provision, section 128. Now under 128, not only do you require to go to referendum as part of the amended process, but that referendum is in 3 filtered stages. One is you require a simple majority of the persons voting in the states. The second is you require a simple majority of the states themselves. And the third is you require overall a simple majority of 51% of the people voting. This made amendments so difficult that the Australian Constitution till date has only 6 amendments. Next comes our famous Government of India Act, chronologically, 1935. Now, large parts of our Constitution are based on this Act. Again, this is the British Act of Parliament. And it is the longest, perhaps, Act of the British Parliament ever enacted, 321 sections. This gives us our present cabinet system of government. You will find in our parts 4, 5, 6, etc. very elaborate provisions laid as to the Houses of Parliament, as to the Prime Minister, the Council of Ministers, aiding and advising the President, etc., etc. All this is very heavily borrowed from this Government of India Act. What is also borrowed is the part relating to public service commissions, services under the state, Comptroller and Auditor General, and of course the famous 3 lists in the 7th schedule. Because it is this act which for the first time brought into force a concurrent list, where both Parliament and the state legislatures could, on certain subjects, themselves concurrently legislate. Now, having said all this, what then was the great innovation made by the Constituent Assembly? Please remember, there were deliberations over almost 3 years between December 46 and November 49. It took 3 years for them ultimately to look at these various documents and others, including the Constitution of the Free State of Ireland, which formed a very important document as well, of 1937. And ultimately, they gave to themselves a preamble. Now, what is interesting about our preamble is that the preamble was drafted last, even though it appears at the beginning of the Constitution. It was ultimately drafted and passed only in October 1949. So that it could, in one sense, be said to tell us what our Constitution is all about. Now, the preamble begins with the fact that we are a sovereign democratic republic. We are sovereign because we have shaken off the English coin, so to speak. We are democratic because today we believe in adult franchise. And we are a republic as opposed to a monarchy because we have a president at the head. And 361 of our Constitution makes it clear that, like the English monarch, while he is president, he cannot be criminally prosecuted for anything. Now, having said this, the rest of the preamble is what really tells you what is new in our Constitution. First and foremost, it speaks of justice, social, economic, political. It then goes on to the French Revolutionary Creed, liberté, égalité, fraternité. Liberty, equality, and fraternity. Liberty is of thought, expression, belief. Equality is of status and opportunity. Fraternity is very important, a cardinal value usually missed, because it assures the dignity of the individual first, which in turn then assures the unity of the nation. This then is the preamble of our great Constitution. Therefore, what was new was the first part on citizenship, because naturally, in British India, citizenship meant citizenship of the United Kingdom. Here, for the first time, we were told that persons who were born here, naturalized here, or had spent a certain period of residence here were entitled to be citizens. This is a new part altogether. But what really is the heart and soul of the Constitution is the fundamental rights and the directive principles. And it is these that really flow from what I have told you in the preamble. First, the fundamental rights. You have an entire part 3 on these rights. And they begin with a definition of state, because it is now a measly little individual who can approach a court of justice and ask that court of justice to do justice in his case against the state. A very, very major leap, a massive innovation by our founding fathers. State is defined tentatively as including. It's an inclusive definition. The legislature and the executive, while not mentioning the judicial branch, at that point of time, perhaps they felt that this requires to be evolved by case law. Indeed, it has been evolved by case law. And we have yet kept the famous Shelley versus Kramer doctrine open in this country. Because Justice Bhagwati went as far as saying, I would have deliberated and decided on this, but my colleagues were not with me. So, it yet remains open as to whether the judiciary is part of the state. We have, of course, a 9-judge bench judgment in certain circumstances, which says that it is not, but it is only in very circumstances. Naresh Mehrajkar's case. Having said that, you come now to the famous Article 13. 13 is what gives us and gives courts the power of judicial review. Something which Chief Justice Marshall had to cull out of the US Constitution. It was not expressed either. 13 gives this as a gift to us and is in two parts. The first part deals with pre-constitution laws. The second deals with post-constitution laws. Now, 13 again brings very, very interesting problems of interpretation with it. What happens if an act is passed pre-1950, offends a certain fundamental right, and then the fundamental right itself gets amended so that the offence gets removed? Early, our Supreme Court held in the 1951 and two 1955 cases that they would apply what is called the doctrine of eclipse. That is, for these laws only a shadow is cast, and when the shadow is lifted, the law comes back to life. That is not the same with laws made under 13(2), which become void at their very inception. But this also raises interesting questions of interpretation. Suppose a law under 13(2) is void as against a citizen, because you remember, unlike 14 and 21, 19 is quasi-citizen. So suppose it offends a fundamental right under 19, it will still be valid by persons, that is aliens, persons who are not citizens. Is it then valid or is it stillborn qua all? This again was decided in Dipchand's case in 59, saying that no, by a 3-2 majority, it is in fact bad qua all. Then comes the famous Article 14, again a gift. It took the US a civil war and 70 years for them to have their 14th Amendment. Because our Article 14 fundamentally embodies exactly the same thing. It gives every citizen, in fact every person, the equal protection of the laws, which is borrowed directly from the 14th Amendment of the US Constitution. Article 17 goes hand in hand, which again is like the 13th Amendment in the US Constitution. Here it is untouchability, there it is slavery. But all this is given to us on a platter. It took the United States 65 to 17 years after a civil war which almost destroyed their union to get these great rights. Article 18 equally is an article borrowed from there, borrowed in fact from Article 1, Section 9 of the US Constitution, making it clear that we are a republic, that we cannot accept titles of nobility from anybody, least of all in fact from our own government. 19 is a very interesting provision in that it gives a whole facilis of rights. Now 19(1)(a) is the very, very important basic right for any democracy or freedom of speech. This is not given in the First Amendment's terms, because the First Amendment says Congress shall make no law. Here in fact what they have done is to enter into a balancing act between the individual's right to speech and various subjects qua which the state may make laws. There are 8 enumerated topics. If it goes outside the 8, sorry, your right to free speech is inviolable. The next is the famous right to assemble freely. And please mark the words without arms. The Second Amendment to the US Constitution is the exact opposite. That we shall have a well-regulated militia for which it is necessary for citizens to bear arms. Just now, the United States has been embroiled in tremendous controversies over gun-toting lunatics who have murdered innocent children. If at all the President is able to in fact confront the gun lobby and propose an amendment to suitably amend the Second Amendment, this itself would take years and years, because not only do 2/3 of the houses of Congress have to pass it, 3/4 of the states have ultimately to ratify. Now all this led to our 368, the amendment provision, about which I will speak a little later. But imagine the importance of saying that you will assemble peaceably but without arms. That's part of the genius of this nation. Non-violence being rooted in. The third is the right to form associations or unions. Now this is directly borrowed again from the Irish Constitution. And the fourth and fifth, with which we are directly concerned, given persons like Raj Thackeray and his statements, is the right to move freely throughout the territory of India and the right to reside and settle anywhere. Guess where these provisions came from? They came from a 1920 constitution of the free city of Danzig. Now Danzig, as most of you probably know, is right in the north between Germany and Poland, and used to be a city which was often captured by one or the other depending on which side Poland was. And it was therefore a border city which required post-World War I to be given various rights. And this right of movement was crucial for that city, so that both Poles as well as Germans could walk in freely and reside wherever they felt. Similarly, then you have the right of property, the right of business. Now, one very interesting thing happened so far as property and liberty is concerned. Sir B.N. Rao, as I told you, was our constitutional advisor, and actually not only sent out questionnaires, but also visited many foreign nations. One of the nations he visited was the US. And one of the people he met was Justice Felix Frankfurter. Now, Justice Felix Frankfurter was really a Harvard don, a Harvard professor, who later became a justice of the US Supreme Court, who believed in James Bradley Thayer's great article in For Harvard Review, Law Review, stating that our hands judicially should essentially be off. He was the opposite of an activist. He warned Sir B.N. Rao and told him that, look, when you adopt your constitution, be very careful not to use the expression due process. Why? Because when our Fifth Amendment, that is the US Fifth Amendment and 14th Amendment, uses the words due process, the Supreme Court had in the early 1900s applied the due process clause to say that they would interfere with legislation and policy decisions depending on what they thought policy should be. That was called the Lochner era. Lochner was the first important judgment, which led to this series of judgments, which went on till the 1930s. So Sir B.N. Rao came back with this. He also, of course, met the others. And here in an aside, Justice Douglas was of the opposite view. And Justice Douglas and Justice Frankfurter had this healthy rivalry on the bench. Very often they would pass little notes to each other. And when once one particularly poor counsel appeared before them, Douglas sent a note to Frankfurter saying, "This must be one of your star students at Harvard." So, ultimately, unfortunately for us, the Frankfurterian view prevailed. And we separated liberty and life from property. Now, the original idea was that you will separate liberty and life from property because you do not want substantive due process with property, not the other way around. What actually translated itself into the Constitution was that Article 21 used the expression procedure established by law so far as life and liberty is concerned, and they borrowed it from the recent Japanese Constitution instead of borrowing it from the American Constitution. And so far as property was concerned, you had a full-blown substantive due process in both 19(1)(f) and 31. It took the Supreme Court and the legislature 27 years to remedy this imbalance. 27 years later, what happened was, in 1978, Maneka Gandhi's judgment came. And that judgment for the first time told us that the procedure established by law could not be law and full stop. The moment you have a law by the legislature, out goes liberty. No. The procedure itself should be just, valid, reasonable. From that first very important step towards substantive due process comes the judgment in Mithu's case, which is a 1983 judgment, where Article 21 was used now substantively to strike down a provision of the Indian Penal Code. And it is from Mithu's case onward that we have today a full-blown substantive due process so far as liberty is concerned. I counted the other day, there are as many as 23 fundamental rights buried in the innocuous language of Article 21, which have come to light now because of judicial decisions. Property, of course, took its swing the other way. As you know, the very Constituent Assembly which gave us this Constitution passed the first amendment as a provisional parliament. Because what happened here was that it's only in 1952 that our first general election took place. And in 51, the very assembly, which now was the provisional parliament with Prime Minister Nehru and Law Minister now, Ambedkar, made Articles 31A and B, which were very, very serious inroads into fundamental rights and fundamentally property rights. 31A, as you know, was necessary because of agrarian reform. Surely Parliament could have waited for the Supreme Court to deliberate on it. There were differing high courts at that time, but they didn't. So they said that the moment there is any law which is passed by agrarian reform, out goes the equality principle, out go all the rights under 19 and the rights under Article 31. 31B, of course, was an extremely draconian provision which frankly was unnecessary but added as a matter of abundant caution, which of course led to a series of ills later on. But that provision then said that the moment you amend the Constitution and put an act in a schedule, which is the 9th schedule, that act not only becomes immune from attack on the ground of all fundamental rights, not just 14, 19, 31, but also resuscitates in terms of life if struck down by a Supreme Court judgment. It's very, very far-reaching. And all this was done by the very Constituent Assembly which gave us these rights. Dr. Ambedkar had said something very remarkable. Of course, when he was a drafting committee member and not when he was a law minister. He had said, when told, that look, your legitimacy as a Constituent Assembly is only 28% of the popular vote. Wait till the general election takes place and let Parliament then do what it likes. His answer was very telling. His answer was that as members of a Constituent Assembly, we have no axe to grind. The moment you become a minister, you have a government policy which you have to push through and therefore you have axes to grind. Very interesting and something which he himself ultimately betrayed. Because the moment he became law minister and piloted the first amendment, out went fundamental rights. Coming back now to Articles 23, 24, they are innovative and very good in the sense that they prohibit child labor, beggar, etc. When we come to the rights of religious minorities, they are largely borrowed from the Irish Constitution, again, 25, 26. And they tell us that every person has the right freely, not only to profess, but also to propagate religion. Now the word propagate was added by amendment later, it was not there in the original Constitution. The last draft added the word propagate, which led to a debate on what it meant. Did it only mean the putting forward of views, or did it also mean the right to convert? Now this came up before our Supreme Court in Reverend Stanislaus' case, and the Supreme Court rightly, in my opinion, said that there is unity in diversity in this country, You can certainly say what you like about your religion and other people's religion, but you cannot have the right to actually convert somebody under this word propagate. And of course, all these rights are subject to public order, morality, and health, which are again words borrowed directly from the Irish Constitution. Article 27 is now borrowed from the Swiss Constitution. Just look at the panoply of things that were debated, and ultimately you arrive at a certain conclusion and borrow something from somewhere. Now 27 specifically says that the government, if it levies taxes, cannot utilize those taxes for any particular religious body. In the United States, you have a complete wall between religion and state. Here you have a wall which is somewhat like the wall in Midsummer Night's Dream, where Pyramus and Thisbe speak to each other through little holes and cracks. Now the holes and cracks are to be found in Article 28. In 28, you are told that even though an institution is aided, you can yet have and conduct not only religious services but religious classes, of course with the consent of the parent of the child concerned. Similar is the case with Article 30, which was an innovation to us, because we had also to deliberate about whether minorities would get reserved seats, which they had in the 35 Act, and or whether there were to be reservations in public services, etc. It was decided that no, only those who were historically, socially and educationally downtrodden would be given these rights. And instead the minorities would be given the right then to set up their own institutions and teach whatever they wanted to teach them. That is Article 30. 32 was described by Dr. Ambedkar as the heart and soul of our constitution. Why? Because many constitutions, including the old USSR constitution, had these rights. The Chinese constitution has these rights. But who enforces them? Now, without enforcement, these are only written on paper. So you were given the right now for the first time, which is an innovation of our constitution, not borrowed from anywhere, to move the Supreme Court directly for violation of any of your fundamental rights. And what is important is that this Supreme Court would not be like its predecessor. The old federal court under the 35 Act was a court which decided only constitutional issues and gave declaratory judgments. It had no power to enforce its own judgments. Our Supreme Court is perhaps the court with the widest jurisdiction in the whole world. Article 136 vests it with a jurisdiction over every court and every tribunal, and with orders, judgments, determinations of all kinds. So you had this second very, very important innovation by our founding fathers, that you vest a Supreme Court with supreme powers over the Constitution. One other very important thing, under Article 145, 5 judges of the Constitution are the final interpreters of the Constitution. This again is something which other nations have had to struggle for. We have had it on a plate, so to speak. That ultimately, following the great debate in the Federalist Paper 78, where Alexander Hamilton goes into the 3 great branches of government and then says that the legislature may well have the purse, the executive the sword, but the least dangerous is the judiciary. The least dangerous branch of government is the judiciary, because it had only judgment. Now it is to this least dangerous branch that the founding fathers, and to 5 of them, stated that you ultimately will be the correct interpreters of our Constitution. This is how flexible they wanted our Constitution to be. Having said this, when we come now to part 4, you will be astonished as to where our directive principles of state policy were borrowed from. Any textbook will tell you, yes, they were borrowed from the Irish Constitution. But they won't tell you that the Irish constitution is a Catholic constitution, Roman Catholic. It begins with an exhortation to the Trinity, the Father, the Son, and the Holy Ghost. And it says, in the name of our Lord Jesus Christ. Section 44 of that constitution also adds that the Catholic religion is given primacy in the Free State of Ireland. Now 45, from where all our directive principles are borrowed from, is in fact a borrowing by the Irish constitution itself from an earlier Spanish constitution, which was pre-37, before Franco comes. That constitution, also a Catholic constitution, borrowed this language from papal bulls. A papal bull is an order given by the Pope sitting in the Vatican. So ultimately, when we speak about weaker sections, when we speak about welfare of the people, when we speak about ownership and control of material resources being so distributed as best to subserve the common good, we are not borrowing from Karl Marx. We are borrowing from the popes in the Vatican. This again was something very, very interesting. And perhaps because of this, and also because we have in our constitution cow slaughter as a directive principle, prohibition of, and prohibition itself of liquor, etc., and the fact that Hindu temples alone will be thrown open under Article 25. I think that the founding fathers very wisely eschewed the word secular. You will find that the word secular was added much, much later by Mrs. Gandhi in the 42nd Amendment. They did not use this word because they were cognizant of the fact that they directive principles of state policy from papal bulls, first, from a Christian theocracy, and second, that our own genius required them also to adapt those bulls to us. Therefore, you had something about village panchayats, cow slaughter, etc. Now, having said this, the other very, very interesting new feature of our constitution is the whole chapter on the Election Commission of India. You will find that not only was universal adult franchise now, at that point of time it was 21 years, now it's been amended to 18, so that anybody who is over 18 now has the right to vote. But what use is that right to vote unless there is an independent body which actually oversees the vote and sees that it's correctly given. We've seen in recent elections large-scale rigging taking place in so many countries all over the world. It is only by establishing this extremely important Election Commission of India with a chief election commissioner at its head who has a tenure of 5 years and can only be removed by impeachment, that ultimately we have had an independent body to actually oversee an election to see that person's democratic rights are in fact put into fruition. This is a very, very important part of our constitution and something done by our founding fathers on their own. We now come to the very interesting amendment provision. Now we have a part 20 of our constitution which deals with the right to amend the constitution. As I told you earlier, the founding fathers were faced with an array or panoply almost of constitutions, starting with a simple majority of parliament being enough, which is the English system or the Canadian system, going on all the way to referendum and so many things in between. It is the US model that they picked up with certain changes. The US model used the phrase 2/3. So that when you amend the constitution today, you must have 2/3 at least of both houses of parliament. Now, unlike the US constitution, which requires 2/3 of the entire strength of the house, here it is enough that you have 2/3 who are present and voting. subject of course to 50%. Now 50% has to be there, otherwise the government can't govern. So, if persons present are voting are more than 50% and you get 2/3 of them, you can change the constitution. Things cannot be more flexible than this. In fact, Sir Ivor Jennings, when he came here and delivered a series of lectures on our constitution, very early in the 1950s, criticized the constitution for being too long, one, and being too rigid. Now, too long it is, but I don't know how it's rigid. It is in fact one of the most flexible constitutions. And the very fact that we've had, as the first speaker said, over 100 amendments, shows you how flexible it is. And the idea really was to keep it as flexible as possible, because as I told you earlier, the Constituent Assembly were weighed down by this fact that they were not actually elected by the entire populace of India. So they felt that a duly elected parliament with universal adult suffrage should in fact be given a free hand. However, they went on, of course, to add a proviso. And certain subjects which really are federal state issues were under that proviso also to be ratified this time by only half the states. You remember, the US Constitution requires three quarters. Here they diluted it to half, so that ultimately the amendment provision would be a provision which would, according to the founding fathers, subserve the needs of the adult population of the country as and when it was felt necessary. Now, one other very interesting thing that Sir B.N. Rao did, he as the constitutional advisor in his first draft wanted two things, neither of which were adopted ultimately by the Constituent Assembly. One was, he said, that I want directive principles of state policy to override fundamental rights. Something which came in Article 31C, 21 years later, by the 25th Amendment. The other interesting thing that he wanted was to borrow from an earlier Irish constitution, a 1922 Act, which had a very interesting provision. The provision was that for the first 8 years, you, Parliament, will by a simple majority be allowed to amend any part of the Constitution. But after 8 years, it will be by referendum. Now here, Sir B.N. Rao felt that perhaps we should give the new Parliament a period of 3 years, like a removal of difficulties clause. And in those 3 years, be able to tinker with any part of the Constitution by simple majority, after which 368 would come in. Both these proposals were shot down, ultimately. And one other very interesting feature of our Constitution, therefore, is that in the proviso to 368, you have a subclause E, the fact that you may amend this article itself, that is the amendatory article itself. Why was that inserted? It was inserted because of a very interesting Irish Supreme Court judgment. In Ryan's case, by a majority of all the judges sitting, with the Chief Justice dissenting, an amendment was made which was upheld. That amendment was that in the 1922 Constitution, when I told you that the initial period of 8 years you could do what you wanted, Parliament there said we substitute 8 by 16. So that now we give ourselves 8 more years to tinker with the Constitution. And the Supreme Court there said that notwithstanding the fact that you do not have anything expressly allowing you to tinker with this article itself, we read it in and we say, yes, this 16 years passes muster. In 37, when Ireland gave itself its own constitution, it therefore did not subscribe to the majority view in Ryan and deleted this 8-year period altogether. So that from the start in 1937, anything that you want to do by way of tinkering with the Constitution, you can do only by referendum. So coming back to our 368, you can see how difficult and how numerous were the various avenues open to our founding fathers. And ultimately they chose what they thought in their wisdom was something in between, so that at one go you can say that, look, we have not made it so easy as to make it almost like simple legislation. But at the same time, we have not made it so difficult, because we don't want everything ratifiable by states, and neither do we want to send things to the people. One very interesting amendment which was made by the Janata Party, and it was only a bill, and it never ever passed muster, is the 45th Amendment Bill, where referendum for the first time was resorted to by a government. You remember in Keshavananda Bharati, the basic structure doctrine which has been laid down has now come to stay. So what the Janata Party did was to try and institutionalize it by saying that, look, these 4 features and these 4 features alone will be deemed to violate the basic structure. One of them was any change in fundamental rights. And if it violates basic structure, then unless 51% of the people ultimately pass the amendment, it will not pass muster. But this experiment, like many other experiments, have fallen by the way. One other very interesting feature of our constitution was the problem of language. Now, India in one sense is the Tower of Babel. I don't know how many. And the interesting part, I have a very little noticed Article 29 in our fundamental rights, which gives every section of the citizens the absolute right to preserve language, script and culture. So the Indian way, which is the opposite of the American way, is to see that we have unity in diversity, and diversity is constitutionally protected. Now with this, how exactly are we to give ourselves a national language? True, Hindi may be spoken by the northern states, but it's not understood in the southern states. How can we carry on with English? It's a foreign language. Now all these questions the Constituent Assembly faced. And finally they came out with a compromise formula. The formula was, we will continue with both English and Hindi for 15 years, set up a commission, be then bound by what the commission says. No, it is not possible to dispense with English. And finally we had our Official Languages Act of 1963, which now is the law, which says English, Hindi and in some circumstances regional languages as well. The so-called trilingual formula. All this again is as a result of the wisdom of the Constituent Assembly ultimately in saying both should continue and leaving it to the wisdom of the future to decide how we will ultimately govern ourselves. Now, having given you the broad outlines therefore of our constitution and very broadly told you again from whence they come, I end with only one small exhortation, and it is this: no constitution, however superb it is, however well it is drafted, can ever subserve the needs of a people. One, and two, the people themselves are up to the task. Every one of you as citizens of India, including all of us and persons sitting on the dais, have to make this constitution work. Thank you very much.
Thank you, sir, for tracing the origins of our constitution in such a lucid and eloquent manner. All of us feel deeply